Let's talk now about looking for intention to create legal relations in a contract with the government. Just want to start with some just basic premise stuff. You need to understand that governments are capable of entering into contracts with private corporations or citizens. However, it's important to be able to distinguish between contractual relationships that a government might have as opposed to policy statements or ongoing government services that can be increased or withdrawn depending on what's happening politically, who the government is, what's happening in the budget or otherwise. And so one of the things that has happened from time to time is that the courts have needed to determine and differentiate between commercial contracts with government and decisions that governments make which are policy or services related. So in transactions with the government, it's necessary to distinguish between, as I mentioned before, the commercial agreement and those involving the implementation of policy. A couple of key cases here, well, there are really three: the administration of Papua New Guinea and Lae, Australian Woollen Mills, which we've spoken about a number of times, and placer developments. So in administration of Papua New Guinea and Lae, that's the case that involved the Department of Agriculture spraying Lae's cattle under a tick eradication program. I think I've mentioned this in class, actually. This basically what happened is it was done very badly. A number of the people who were being paid to do it were drunk, sleeping on the job, and it actually caused more damage than good. And so Lae sued the administration of PNG, which was at the time an Australian territory, in contract, sued for damages. And ultimately, the action in damages was rejected because there was no contract. The arrangements were not contractual, as the department was simply providing gratuitous assistance under government policy. I think the reasoning is much clearer in Australian Woollen Mills, and I think that you'll see that Lae really followed this methodology, or the finding of the court. To really get your head around this, read carefully section 5.6 of your textbook. But you'll remember the facts of AWM. So Australian Woollen Mills bought some wool, bought wool, that's what it did, and it manufactured goods with that wool. The Commonwealth Government announced a subsidy to woolen product manufacturers regarding wool purchases, but subsequently withdrew the subsidy. Woollen Mills claimed damages of £108,982, so quite a large amount of money back in the 1950s, as arrears under the subsidy in breach of contract. And the High Court ultimately held, for a unilateral contract to arise, the promise needed to be made in return for the doing of an act. There needed to be a quid pro quo. We talked about that when we were talking about consideration. So the act itself needs to be done at the request of the promisor. And in this case, the subsidy was a government policy, not an offer. So in looking at the intention point, though, the High Court saw that the Commonwealth Government did not intend to assume a legal obligation to pay the promised subsidies to the manufacturers of woolen product. The absence of an intention was indicated by four factors. Firstly, no statutory authority was sought for the making of the payments, as one would expect if a legal obligation was being assumed. Secondly, the scheme was announced by persons who had no power to commit the Crown to any expenditure. Thirdly, the Commonwealth had no commercial interest in the purchase of wools, but was simply dealing with a problem that was created by the war. Fourthly, the Commonwealth expressly reserved the right to vary the amount of the subsidy. And this actually went to the potential illusory nature of the promise. The existence of such a discretion was inconsistent with the notion of the Commonwealth the notion that the Commonwealth intended to assume a contractual obligation. Ultimately, the Privy Council agreed that the scheme was administrative rather than contractual, and the lack of a formal agreement and the number of uncertain factors pointed to this conclusion. And the Privy Council thought that it wasn't remarkable that manufacturers were content to rely on the Commonwealth's statement of policy. So you might like to compare this and lay with Placer Developments. That case involved the agreement again between the government in New Guinea and Placer, which was a timber company. One of the clauses of the agreement provided that a customs duty would be paid on the importation of timber products to Australia, and the Commonwealth would pay the timber company a subsidy at the rate to be determined by the Commonwealth. And Placer sought to enforce this agreement, essentially to get rid of this tax. Justices Owen, Taylor and Kitto said that the clause was unenforceable because it was an illusory promise. And so we'll talk about that context again more when we talk about certainty. What I think is really interesting here from an intention point of view is the dissenting judgment. So it is obiter, but the judgments of Menzies and Windia, neither of them had any doubt that the agreement was intended to create a legal relationship. They looked at the language of the contract, which was language that was sought to create a legal obligation. And they saw that the agreement between Placer and the government had an essentially commercial character, and Parliament itself had approved the agreement and appropriated funds to meet the obligation. These factors were enough to rescue the agreement from what they called the unenforceability which a purely political arrangement has, and to give it commercial character. So I would argue that Placer actually also reinforces the terms or the four criteria that you see in Australian Woollen Mills. And if you work through those dissenting judgments, whilst ultimately the decision was made on a different point, the illusory point, you see that those factors were all relevant, but because the facts were different, the outcome was different. So I'm going to move on to preliminary agreements next. Thanks for watching so far.